So, Scott, when we broke, you told us, as we were previewing this SCOTUS term, you told us about the Gill case that deals with gerrymandering. You told us about Janus versus AFSCME, the American Federation of State and County, which is, and I hope people remember, is basically Friedrich's Redux.
Right.
But now that Scalia, when he passed away, could not rule that public sector unions should be basically handicapped. We should just remind people that, you know, what happens if you're working in a union shop, if you're working for a municipality, the city government doesn't want to negotiate with every single person who is a sanitation worker. So they negotiate once with the sanitation union. And if you're one of those sanitation workers who don't want to be a member of the union, that's fine. But you got to pay for the lawyers who are making you extra bucks and making sure that you get time and a half, et cetera, et cetera. So,
Exactly.
we may see the Supreme Court basically strike that down, which would seriously inhibit the ability of unions to do anything, even negotiate on behalf of their members. So that is a very disturbing case that it looks like with Neil Gorsuch on the Supreme Court, there's no way to fend off, unless, of course, God forbid something was to happen to one of those five Supreme Court justices. And I don't know. I'm a little bit more of an atheist, so I feel comfortable saying that. But all right. So tell us of some other important cases that might be coming up.
Sure. Another important case is the Masterpiece Cakeshop case. And this case is about whether the state of Colorado can apply its civil rights laws to a baker who refused to bake a cake for a same-sex couple. So that's, this gets right to the heart, and this is, of course, one of the ways in which conservatives are trying to chip away at civil rights protections for gay people. And, again, this is, the foundation of civil rights law is that there's a difference between your home and your business, that you are free as a person, if you don't want to attend a same-sex wedding, if you don't want to volunteer, serve as an usher, you're allowed to do that. You're allowed, for that matter, not even allowed to allow gays and lesbians in your house. But once you open a business, it's different. When you're a public accommodation, and this has roots going back to English common law, you have to serve all comers. A hotel can't exclude African Americans or women from staying there, and the same thing. So that, basically, federally, there's no protection for sexual orientation civil rights law, but there is at the state level. And Colorado essentially said that, if you're a bakery, if you're open for public, you have to serve your customers on an equal basis. One interesting thing is that
is the argument they're making, like, though, I'm a baker. This is how I express myself. I'm a First Amendment. I have First Amendment protections because baking is my art. Or when I'm a wedding photographer, the photographs I take are my art, and I don't want to be forced to do a artistic project that I don't want to. I mean, what do you make of that argument?
Yeah, and so it's a clever argument. So that you might think they'd make a religious liberty argument, but under the precedent, under the Employment Division versus Smith precedent, the Supreme Court is pretty clear that a neutral law can burden a religious practice incidentally. So you can't say this violates my beliefs because, since the law isn't targeted at Christians or anybody else, the law applies equally. So that wouldn't fly. So what they're trying to make is a First Amendment argument. This idea that, baking is a form of artistic expression. So that, the sort of implicit argument is that this would be a narrow argument because, if you get a steak made it Safeway and kind of a, industrial process, then that's a different issue. But, this is a local mom and pop bakery, so it's a matter of artistic expression. But the problem is that it's not as narrow as it seems. Like, Subway calls their employees Subway sandwich artists. Like what,
Right.
I mean, what it does a cake being made in a supermarket less, or, artistic expression. So, it's a clever argument that it appears very narrow on its face, that it can kind of reassure Kennedy, like, we're not doing too much to undermine, it's just this little thing, it's only applies to mom and pop bakeries. But, I think the way Alito and Gorsuch would see it is it's a foot in the door that you make what appears to be this very narrow limitation, but it's also one that you could drive a truck through, because it's going to be very difficult, if the court buys the argument, it's going to be very difficult to sort of start making distinctions about what's, when does running a business become a form of personal expression and when is it just running a business. So it would be even if the opinion on its face seems narrow, I think it have really wide-ranging implications. And again, that also puts the gerrymandering case in irony, is that, conservatives are pretending that, we can't ever address gerrymandering because what if there's a future case that's tough and, we can't create a rule that will cover everything. Well, they're pretty comfortable doing that when it comes to same-sex marriage. They're willing to leave a lot of questions open. So it's a little disingenuous.